All right. Well, I think I am live. Hopefully, the right buttons have been pressed and you can see me. Well, welcome everyone. My name is Lior Samfiru. I'm the employment lawyer. And you know why you're here. You're here to find out about employment law. You're here to find out about workplace rights. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in Canada. And I like to do this very much. I like to come on here and answer your questions live about workplace rights, about employment law. We have amazing, really good laws in this country. Okay. And a lot of people that think that they don't have rights, it's because they don't realize how good the law is. Well, the law can't help you unless you understand what it says and what it does. That's why these sessions are important, to help you, to educate you about the rights that you didn't even know that you had. So if you're facing a workplace problem, a dilemma, a deadline, an ultimatum, whatever you want to call it, maybe you've been put on a leave, maybe you lost your job, maybe you're being mistreated, maybe you're off on a disability and you want to know what your rights are. Whatever the workplace issue or problem, now is the time to ask those questions. Now is the time to come on here, type your question, and get that answer so that you know what to do, so you feel better. Now, let me give you some other information as well. I can answer your questions here, and I'm going to answer your questions. But what I can't do on Facebook or on YouTube is actually do something for you, solve your workplace problem. To do that, you have to connect with me off social media so we can have a discussion and figure out what to do. To do that, all you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see the phone number, the email address. It's all there. Allows you to connect with me and my team. We have a team in Ontario, in BC, and in Alberta, just dedicated to helping you with your workplace rights. So whatever the issue, I promise you there's a solution and answers. And now is the time to ask those questions. So right now, and we're live. This is a live session, and it works that much better with you asking questions about what problems you're dealing with in the workplace. So feel free, ask those questions. Don't be bashful. Now, as I'm waiting for those questions to come in, let me tell you about something that I always see and I always deal with, and people often get confused about this, and that is going off on a disability. Listen, let's face it, with COVID-19, a lot of us have felt extra stress, anxiety, between family and COVID and work. Sometimes it's too much. And I've spoken with many people that spoke to their doctors and felt that they needed to take some time off work to recuperate, to recharge their batteries, to feel better and healthier. So I wanted to talk about how do we do that legally? How do we get time off? Well, it starts very simply with a doctor's note. Okay, all you have to do to be able to get off work, to take time off work if you're sick, if you're not well, is a doctor's note. Your doctor has a lot of power. I like to say that your doctor is judge and jury when it comes to your ability to be off work. So if you have a doctor's note that says you need to be off work, whether it's for an unknown period of time or if it's for a day or for a month, then your employer has to give you that time off. There's no way to question it. There's no way to deny it. There's no way to let you go, to threaten you. You can take that time off. Okay? It starts with that doctor's note. Now, what it's not enough is not enough necessarily for you to say, employer, I'm sick, I'm going to be off for a while. Your employer can absolutely insist on a doctor's note. But if you have that doctor's note, that's very powerful. Now, I know that there are situations where people are concerned that their employer is going to want to know specifics about their medical condition. The employer may say, well, wait a second, what is your condition? Is it depression or is it a bad back? And I want to know what treatment you're getting. Well, wait a second, not so fast. Okay? Your employer does not have the ability to know about your medical condition. They can't ask questions about your diagnosis. It doesn't matter if you're suffering from a bad back or from depression. What matters is whether you can work or whether you cannot work. And if you cannot work, and that's what the doctor says, that's enough. And if your employer wants to know specifics about your condition, you're absolutely able to say, no, I'm not going to provide that to you. I gave you my doctor's note, says I can't work. I'll let you know when I'm able to work. And that's all I'm going to do. Okay, so an employer cannot fire you for not telling them what the medical condition is. Okay, so very important to remember that. Another thing an employer cannot do is demand that you go see another doctor. Okay, so they can't say, well, I'm not buying what your doctor's saying. I want you to see another doctor that I'm going to pay for. No, Your doctor, as I said, has the power, right? So if your doctor says you can't work, that's it. And your employer can't demand other information, or I shouldn't say demand that you see another doctor because they don't like what your doctor has to say. Absolutely not. By the way, everyone joining us, my name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. And I am here, of course, informing you and educating you about employment law. Okay. But as I said, this works that much better if you ask your questions about the things that you want to know, the problems that you're having. Okay. I can sit here and talk all day about employment law, no problem. Just try to stop me, not an issue. But I think it's better for you if you say, well, here's my issue. What do I do? Am I right? Am I wrong? Can my employer do this? Whatever the issue, whatever the problem, now is the time to get answers to those questions. As I'm waiting for those questions, let me continue a bit about the discussion about going off work. So in some situation, you may need to be accommodated, modified duties, modified hours. Here, also, the doctor has that power. If you need accommodation, you need your doctor to say so in writing. Maybe your doctor says you need to work part-time, reduced hours, different job, work from home. If your doctor says that, your employer has to make all efforts to make it happen. Even if it's tough for the employer, they still have to figure that out. Under our human rights law, that's their obligation, okay? So if your employer won't accommodate you, that's a human rights violation. You need to call me at that point. I can usually get that resolved for you, okay? So very important to remember that. I'm going to start answering some questions. Let's see, from first question today from Keith on YouTube. Is disability, race, age all different in the wrongful termination case, or are they all the same? I'm not sure I understand the question, Keith. If you've been discriminated, that's illegal. Whether it's based on race or age, it's illegal. That's different than a wrongful dismissal case. Those can be separate or together. So I'm not sure I understand the question there, but feel free to re-ask it if I've missed something. Next question from Deepak on YouTube. How much notice do I have to give to quit my job? I worked 2 years as a computer programmer. There's nothing in the contract. Well, that's the starting point always, Deepak. It's does your contract say something? If your contract doesn't say that, you have to give essentially reasonable notice. What that means is how much notice really does your employer need here to be okay? In most cases, that's not going to be more than 2 weeks. Now, if you're in a very specialized position that's going to be very difficult to replace and your employer is going to be in big trouble if you leave and there's no replacement, the law may say you have to give more notice. So that applies, again, if you're in a very unique position, difficult to replace, and where the company is going to have to suffer if you don't give enough notice. In most cases, 2 weeks is going to be enough. Certainly 3 weeks, you're fine. But again, if you're in a very, very unique situation, you may have to give even more notice. Generally, the more, the better, right? Because you also don't want to burn any bridges. But it's going to be very difficult for your employer to pursue a case against you because you didn't give enough notice. That almost never happens. It can, but it almost never happens. So usually 2 to 3 weeks, you're fine. Hopefully that answers the question, Deepak. Happy to do any follow-up. So see how easy it is, right? You type in your question, you give the information, I answer the question. Very simple, very straightforward. Those joining us right now, welcome. My name is Lior Samfiru. I know it's a bit of a mouthful. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, BC, and Alberta. We help people with their employment cases and their disability cases. If you have an issue where your insurance company, for example, won't approve your disability or they're cutting you off disability before your doctor says you should be cut off, we can help you with that. We have a whole team. So right now, though, I'm live. You're live. Ask your questions. I'm going to continue answering them. So let's have that discussion. Irina asks, I was fired for cause from work because of vaccination policy in October. How much time I have to sue them for that? You have 2 years, but why would you wait? You already were let go back in October. Let's do this now, okay? It's not cause, okay? So there's no reason in the world why you're going to wait, why you should wait any longer. In fact, I would have already done it. If we had taken legal action in October, we probably would have resolved it by now. So Irina, let's have a chat off Facebook, off social media. To connect with me, easy, you just go to employmentlawyer.ca. Again, employmentlawyer.ca. untitled.ca, and phone number is there, email address is there. It's all there to connect with me. Okay, so I wouldn't wait on this, Irina. Okay, next question comes from Andy on YouTube. My wife works for a US company as a data analyst. It's all online and typically has changing hours and inconsistent pay periods. Will the New Workers Act have any impact on her position? Yes, if she physically works here in Ontario or wherever province she's in, it's the laws of that province that apply to her. So it doesn't matter where the company is located. What matters is where she's physically located. The province that she works, the laws of that jurisdiction are going to apply to her. Okay. Oftentimes, U.S. companies don't understand that. They think that their laws are going to apply. It doesn't. So if she's physically located in Ontario, as an example, that's all that matters. And if they don't comply with the law, let me know. We can deal with that. Hopefully that answers that question, Andy. Very good one. It's a question that a lot of people are asking and are wondering about. So very good question. Okay, next question from Trinafail Rose. Does your employer have the right to constantly contact you regarding your time off work once you have provided a doctor's certificate? Absolutely not. That's a great question. If your doctor says you need to be off work, they shouldn't be calling you and bothering you. And in fact, you should tell them that. What you tell your employers, when I have an update, I'll provide you an update. Or even say, listen, I'm going to speak to my doctor next week. I'll give you an update after that. They shouldn't be contacting you. They shouldn't be asking for any information that you've already provided. And you're absolutely able to tell them to stop doing that. If they still bug you, let me know. I can get them off your back. But that's a very good point. And it's a very good question. No, if you've answered the question, it's okay to say enough is enough. I'm at home. I'm working and getting better. I don't want to deal with this. And I'll give you an update as soon as I have an update. Great question. Guys, I'm going to continue answering questions. We have a bunch coming. Keep asking your questions. You still have time. I'm live. Okay, I'm live here not because I like going in front of a webcam. I'm live because I want to help and I want to answer your questions right now. Okay, ask those questions. I'll answer them. Again, my name is Lior Samfiru. Let's get to work. Christine, next question on Facebook. Oh, it says Steve here. Okay, I'm on STD for the second time in 4 years. After a harassment claim found the harasser guilty on 8 counts. Unfortunately, I was put back on to work with that same manager, hence why I'm on STD again. My question, can you ask for a severance or does it have to come from the employer? Well, you can ask for severance, and if you can show that your employer did something wrong, then that makes it difficult to continue working. And it's not asking for severance. We would have to take legal action. If you go to your employer and say, hey, pay me severance, you're not going to do that. We have to get involved. So to be able to get severance here, Steve, we would have to be able to show that your employer screwed up in putting you back to work with this manager, that it was unreasonable. They should have done something else. They could have done something else. And the fact that they didn't caused you a medical harm, and then enough is enough. So if you can show that they screwed up here, absolutely. We call this a constructive dismissal. Their actions, their screw up, is effectively a termination of your employment, and yes, you can get severance. So obviously, I would want to speak to you. I want to find out more about the harassment, what had happened, when it happened, and what happened after you went back to work the first time. So there's a lot of information that I need here, Steve. So you really want to connect with me as soon as possible. For Steve, for anyone else, if you want to connect with me off air to have a private discussion with me or my team, all you do, see that address right there, employmentlawyer.ca. Again, employmentlawyer.ca. You'll find email address there, phone numbers, forms, everything is there. You reach out to us, we connect with you, we help you. Okay, next question to us today from JC2004 on YouTube. Can a potential employer refuse to accommodate a potential new hire's disability, or is that discrimination? I understand they might have to accommodate a current one, but what about a new one? Yes, they absolutely have to accommodate a new employee the same way. They can't refuse. The duty to accommodate applies to all employees. From day one until the last day of work, you have to be accommodated. And if an employer doesn't accommodate, if the employer were to say, well, you're a new employee, so we're not going to bother with you, illegal. That's a human rights violation. It's a big deal. So an employer must accommodate all employees as long as they can, and as long as there's a valid reason for that accommodation. If it's a medical accommodation, it would have to come from a doctor. Okay, continuing today. Great questions today. From Rocket on YouTube. Is an employer allowed to deduct damages or replace items lost from employees' paychecks? If not, does it change if there's an employment contract, I think I mean, that says they can deduct whatever the amount is? So generally speaking, an employer cannot deduct stuff from your paycheck unless you've given them your consent in writing. Okay, so depending on how specific the employment contract is, that may be enough of a consent. So I'd have to see the employment agreement. But generally speaking, if the employment contract doesn't specifically give them the power to deduct, no, if you owe them money, they can't deduct stuff from your pay. That's illegal. That's a breach of the Employment Standards Act. Okay, so it's a great question, and many people, I think, have the same issue. Okay, next question today from Yolanta on Facebook. My boss decided to close the business. Maybe for 1-2 months, I will be without a job. Can I expect to receive a severance package? I'm here over 4 years and I'm 61 years old. It's going to be difficult to find another job. So what I'm not sure, Yolanta, is why do you say that you're going to be without a job for 1 to 2 months? How do you know? Because you say it's going to be difficult to find another job. I think maybe what you mean is that it's going to be another 1 to 2 months before you're out of a job. If that's the case, you're absolutely entitled to severance. So if you've been there for 4 years, you're 61, you're probably owed about 6 months severance, less the amount of notice that he gave you. So for example, if he gave you 1 month's notice that you're going to be out of a job, then 6 months less the 1 month means he still owes you 5 months severance. So absolutely. But Yolanta, I wouldn't wait until you're actually out of a job. If you already know when you're going to be out of a job, let's deal with it now so that there's no delay in you getting paid. Okay? So Yolanta, you're owed severance, but let's talk about that. Let's get to work to make sure you get what you're owed. Again, to connect with me, you see it right there, employmentlawyer.ca. Yolanta, that's where you go to, employmentlawyer.ca, and we'll get to work. Barbara, next question on Facebook. If an employee accepts severance pay when terminated for refusing to get vaccinated, do they still have the right to sue? Well, depends on what you've signed. If you signed an agreement, usually it's called a release, that's saying by accepting this, you're releasing us from all liability, then no, you can never sue. If they simply wrote you a check and you took the check, there's no problem, right? So it's a question of whether you signed something. In 99% of cases, your employer is going to want you to sign something before they pay you severance. If you did, then unfortunately, you're probably out of luck here. If you're not sure what you signed, if you're not sure if it's binding, send me a copy. Let me look at it and I'll tell you. Again, employmentlawyer.ca to connect with me and my team. Yes, for those joining us, great questions today. My name is Lior Samfiru. I'm the employment lawyer. I'm answering questions right now about employment law and workplace rights. I'm going to continue doing that, but you still have some time. We still have about 10 minutes or so. So get in your question. Don't leave here without having your question answered, okay? Ask the question. Next question. Okay, let's see. I've answered that question from Rocket. Next question from Mike on YouTube. I got fired from my job. I had an employment contract that stated that severance pay is to be paid pursuant to the Employment Standards Act. Is my severance pay limited? Well, obviously, I would need to see the agreement because it didn't just say that. It said more than that. In about 80% of cases, when the employment agreement tries to limit entitlements, it actually doesn't do that properly for various reasons that I don't need to get into. In about 80%, more than 3/4 of cases, even though a contract tries to limit your entitlements, it doesn't actually do that, meaning you're still owed your full severance. But I have to see that contract. Once I look at it, I can tell you in about 20 seconds whether in fact it limits you or does not limit you. Statistically speaking, there's an 80% chance that it doesn't, but of course we have to see it. Always a good idea to do that, and always a good idea before you sign an employment agreement to have it reviewed, because the difference between having your severance limited in a contract and not having it limited could be the difference between getting 8 weeks severance and getting 2 years severance. It could be huge. It could be hundreds of thousands of dollars potentially. So we want to be very, very careful with these employment agreements. We don't want to agree to something that limits our future severance, And usually we can negotiate that out of an employment agreement. But Mike, let me see the agreement and I'll be able to tell you. But again, 80% of cases that doesn't properly limit, even though it tries to. Keith asks, can an employment case be settled in arbitration? Well, I think if you're talking about arbitration, maybe you're unionized. If you're unionized, then only the union can help you. Okay, so you have to ask the union what that means. JC 2004 says about accommodating a new employee. About essentially, you're asking, can an employer refuse to hire someone because they need accommodation? Absolutely not. Absolutely not. An employer can never say, well, you have a medical issue that requires accommodation, so we're not going to hire you. We're going to hire someone else. That's a human rights violation. Now, of course, the issue is, how do you prove that if you're an employee? How do you prove that that's why you didn't get the job? It's always difficult. But if it can be shown that the employer didn't hire someone because that person would have needed some accommodation, absolutely illegal, a human rights violation. That could be a very, very bad thing for the employer. But again, proof, how do you prove it? Every case is different. In some cases, it's obvious. Other cases, not so obvious. But it's illegal to do that. Guys, I'm Lior Samfiru, by the way. If you don't know, you see it below me. I'm the employment lawyer. Still have some time. I'm answering questions. Ask yours as well. We're here talking about employment law. Okay. Mohammed says, thank you for providing information. Thank you very much, Mohammed. I appreciate that. Next question comes from Heather on YouTube. What are my options? Is it too late for workers' compensation for catching COVID in the course of employment? I have no income source now as a result of getting sick at work. Please advise. Yeah, you can apply to workers' compensation. Now, depending on the situation, it may not be easy to get, but I know a lot of people that have been able to successfully get workers' compensation. Remember, there's also EI sickness benefits. So there's other benefits that may be available to you if you're sick. You have to also see, does your workplace have a short-term disability plan or a long-term disability plan? So there's those things to keep in mind as well. But definitely you can apply to workers' compensation, and depending on how you got it and the type of your workplace, yeah, you may be able to qualify. Jim, next question on YouTube. I'm on STD. Manulife wants me to sign a form allowing them to obtain and share medical info. My doctor needs to fill out forms. Do I need to give them these forms, or doctor's note sufficient? Yes. If they want you to fill out a form, Manulife, you should give that form. Otherwise, you may be in breach of the policy, and that will allow them to say, we're not going to cover you because you didn't do what you're supposed to. Okay, so definitely fill out those forms, Jim. Absolutely. Very important to do that. And again, if you're not sure, by the way, if you're still not comfortable, you want us to look at the form, we have a whole team dealing exclusively with insurance companies and disability issues, so we can take a look at that and let you know. All right, next question on Facebook from Paul, who has one of the nasty boys as his picture. Am I obliged to attend a deposition in relation to my lawsuit against my former employer in relation to a termination? Is it your termination or someone else's? So first of all, I want to make sure you're not American, because we don't call this depositions in Canada. We call them discoveries. If you're writing from the US, then I have no clue about the US. You have to seek legal advice in the US. In terms of here, you have to talk to your lawyer. Your lawyer can tell you, do you have to? When is it happening? How is it going to happen? So you have to speak to the lawyer that you have representing you. Okay. Next question on YouTube from Linda. Can an employer, not for profit, ask if you are vaccinated, and depending on your answer, determine if you will get the job? So here's the thing. It's not, the real question is not can they, the real question is how do you respond? Because if they ask the question, it's not like you can call the police and arrest them. They're asking the question. You have to decide ultimately what you're going to say. It's not illegal to ask the question. And, you know, if your employer doesn't give you the job, there may not be much that you can do in that situation. I mean, arguably, it's a human rights violation that's never yet been tested. So as a practical matter, if you don't get the job, there's not going to be much that you can do. Now, if you're an employee that loses your job because you're not vaccinated, you're working, company finds out you're not vaccinated, you lose your job, they have to pay you severance, of course, because they let you go. If you're not getting the job, can you file a human rights complaint? Potentially. It hasn't been yet tested, so it's going to be very difficult to do. So ultimately, you have to decide what you want to do with your vaccine status. Okay, next question from Andy on YouTube. If my wife's employer is subject to Ontario laws for her position, does that mean that any sort of severance she would be entitled would be the same? Absolutely. So yes, she's not at will. There's no such thing as at will employment in Canada. So whatever severance she's going to be owed if she ever loses her job would be as per the laws of Canada and the laws of Ontario. And that company is going to be shocked by it. They may think they owe her $1.50 if they let her go, or they could be owing her 10 months of pay, whatever that is. So yeah, absolutely. If you're working for an American company, but you're physically working in Canada, Canadian laws apply to you, and that's especially important when it comes to severance. Okay, it's especially important when it comes to that compensation, and the U.S. company doesn't realize that. I assure you they don't. I've seen this 100 times, but too bad, they have to comply with Canadian laws. Now, speaking of severance, let me tell all of you watching how you can find out right now, how much severance you are owed. And by the way, it's not a week per year. It's not 2 weeks per year. It's a lot more than that. How do you find out right now how much severance you're owed? Very simple. Grab your smartphone, grab your tablet. All you do is you go to pocketemploymentlawyer.ca. You see that right there, pocketemploymentlawyer.ca. You can do a lot of things there, but one of the things you can do is use our severance calculator. Okay, you've heard me say it before. Our severance calculator allows you to find out in seconds how much severance you're owed, to get that estimation, that assessment of your severance. It's free. It's anonymous. It takes seconds to use. You don't have to put in that phone number. You don't have to put in a name. You don't have to put in the company's name. You don't have to put in a credit card number, nothing. You answer your age, your position, and the length of your employment, and you find out how much severance you're owed. It's that simple. So use it, take advantage of it. The very first place you go to, by the way, if you lost your job, you're staring at that severance letter, you go to pocketemploymentlawyer.ca. Or you think next week they're calling you into a meeting and they're going to let you go. Go to pocketemploymentlawyer.ca right now. Use that calculator. Find out how much you're owed. Maybe you're worried about losing your job. Maybe you're not, but you're just curious. Hey, what would I be owed actually if I did lose my job? Everyone should have access to that information. Pocketemploymentlawyer.ca. Okay, that's our severance calculator. Over 2 million people have used it. Okay, that's unbelievable. Across Canada, 2 million people. So make sure you use it as well. Last question of the day. How long, that's from JMUFO. I'm not even going to try to pronounce. How long does grievance review board take for a hearing? I'm a union worker. You have to ask the union that, okay? So we deal here with employment law issues, labor issues. Only the union can tell you how long. It depends on the type of case. It depends on the terms of the collective agreement. It depends how reasonable or unreasonable the employer is. So you have to ask your union. And everything, by the way, we talk about in these sessions only applies to non-union employees. Nothing that you hear on this session applies to unionized employees. Guys, thank you very much for joining me today. Always a pleasure. Some excellent questions today, very important questions. I hope I've answered them, but if you have other follow-up questions, or if you want me and my team to get to work to actually help you, easy. You just go to employmentlawyer.ca. You see that below me, employmentlawyer.ca. That's the place to go to, okay? I look forward to connecting with you there, by phone, by email, whatever you want. I'll be back next week, but don't wait until then, okay? Thank you very much for joining me today. I'm Lior Samfiru, the employment lawyer, and this has been our employment law session. Thanks, guys.